Yes, thank you, Judge. Good morning. Caribbean Court of Justice, Appellate Jurisdiction, on appeal from the Court of Appeal of Guyana, hearing of appeal in CCJ Appeal GYCV number 2 of 2024 between Hardat Singh and Ann Narine. The members of this morning's panel are Mr. Justice Anderson, presiding judge.
Good morning, Council. Good morning, everyone.
Madam Justice Raj North Lee.
Good morning, everyone.
Mr. Justice Barrow.
Good morning.
Mr. Justice Jamada.
Good morning to everyone.
And Madam Justice Ononiwu.
Good morning, everyone.
May we have the appearances, please? Thank you.
May it please the court, Devendra Kisoon and Natasha Vera on behalf of the appellant.
Thank you, Mr. Kisoon.
Good morning, Your Honors. Sanjeev Datadin with Ms. Jamila Ali SC, Khalif Gobin, and Mohani Anganu for the respondent, Ann Narine.
Thank you, Mr. Datadin, and we are hearing you quite well.
I'm pleased to hear that, sir.
Wonderful. Okay, so I think we are ready to hear the appeal. Mr. Kisoon, would you be going first?
Certainly, Your Honor. It's the appellant's very simple position that the judges of the lower court were plainly wrong in finding that any monies whatsoever were owed by the appellant to the respondent. In sum, we submit that the evidence that was submitted to the court below demonstrating the alleged debt owed was not sufficient to meet any threshold whatsoever to enter judgment against the defendant. When the matter was first called by the court in dealing with the issue of the enforcement of the alleged promissory note, the learned trial judge made the observation that she did not believe at that juncture that the promissory note was enforceable on its own, and requested that the respondent provide additional evidence to support the note.
Could you remind us of the date when that took place, please?
Yes, sir. The date that the matter was first heard was on November 16, 2020, as evidenced by the fly sheet, the record page 1718 of the record.
Thank you.
And on that date, the trial judge made a finding that she was of the view that the pronote attached wasn't sufficient to constitute a pronote, that aspect of the decision never being appealed by either party, and requested that the respondent submit supplementary evidence to demonstrate that the debt was owed.
Now, are you contending that what happened on November 16, 2020 was the hearing of the fixed date application?
Yes, Your Honor. We are contending that it was the hearing of the fixed date application, and pursuant to the provisions of CPR 8.045, there were required directions that ought to have been given. Either the hearing of the matter should have been heard then and decided, or the matter converted for the purposes of changing the nature of the proceeding. And we do believe that the trial judge fell into error by not proceeding with that course as a mild observation.
Sorry. Counsel, you said to hear it or direct that it be converted?
Yes, in other words, it's
No.
CPR.
Hold on. Is that not, just for my clarification, is that not what the trial judge in fact did? Converted it?
No, Your Honor, because if it is that the matter was to be converted, then a case management conference would have been ordered to have been held, and the matter would have proceeded as if it were a statement of claim in order to get judgment. If it were
Help me here, Counselor. Help me here. It had not yet been served on your client.
No, Your Honor, it had not yet been served, but just taking
So
what Your Honor.
yeah, so no, I'm trying to work along with how you are guiding me. So I'm trying to follow you. For the judge to have converted it and direct a case management conference or whatever, was it not the better thing to simply say, listen, instead of striking this out, I am proposing to convert this. It has not yet been served. So I'm converting it and I am directing that further affidavits be filed, and then the matter of service out was dealt with afterwards. Help me.
Well, Your Honor, just to say that it's our understanding that that could not procedurally have been permissible. In other words, the matter was at no point in time converted, because if it had been converted, and assuming service was effected in a proper manner, judgment could not have been automatically entered in the manner that it was, because if it were converted, then a formal application for a default judgment would have had to have been made pursuant to the rules. In this matter, it appears that the judge appeared to have taken a hybrid approach, ordering that additional evidence in support of the summary application be filed, and thereafter ordering service out of the jurisdiction, all in what appears to be, erroneously we suggest, in furtherance of the hearing of this summary fixed date application. But if it had been converted, that could not have been the process that could have been followed. So yes,
Counselor, I hear you very clearly, but it seems to me that this matter not having been served, some of the steps that you are saying could not justly have taken place. So the judge directs, instead of striking out, I am directing that this matter will proceed as if though it were a statement of claim.
certainly, Your Honor,
And then before she does anything further, it has to be served.
certainly, Your Honor, I agree with the court's analysis, except that I'm perhaps getting ahead of myself one step further.
Okay.
If it were that the court's actions are proper and reasonable, the matter needs to be served and process needs to be followed. In any event, at no point in time was the matter properly converted after service. Because after the pleadings were served, in order for judgment to have been obtained, the judge could not, in our respectful view, sua sponte issue judgment without a further application for default judgment being made. In this case, that was not done. After the judge was satisfied that service occurred, the judge then proceeded to hear the fixed date application in a summary manner and then issue judgment.
Sorry, Counselor, I want to write down what you're saying. You're saying that the judge should have done what before?
Well,
before
after once the matter had been converted pursuant to CPR 8.046, then they and service was effected out of the jurisdiction, as it were, in this case, then a process ought to have followed from that if the matter had in fact been converted. In other words, to get judgment on a statement of claim, it is not an automatic entry at a hearing. There is a process that is enumerated by, I believe, Part 13 of the CPR that requires an application for default judgment to have been filed. And Part 12 of the CPR. And then if that process had been done, there was another process that allowed the appellant that followed from that. In any event, that did not occur. So in our minds, it is clear that what the judge did was retain the fixed date hearing framework, but attempted to case manage and deal with other items, which we would say would be impermissible.
Mr.
Counsel,
Kissoon, sorry, no, you go ahead.
Go ahead, my brother. I've been talking too much.
No, you complete what I want to ask something slightly different about the rules. So you complete what you want to ask, Judge.
Mr. Kissoon, I got the impression from my reading that even though it might not have been articulated since this was a fly sheet entry, etc., that what the judge did at that first hearing was to convert it and direct that it proceed as if though it were a statement of claim. I'm telling you, I got that impression. I don't know that there was any order drawn up. I don't know that there is any note of what the judge may have written on the papers before her, etc. But I'm telling you, my clear understanding is that the judge converted it. I understand you're saying that the judge did not, but I'm just giving you the benefit of my present thinking. I will go back, of course, afterwards and see if I am wrong and you have it right. Yeah.
Mr. Kissoon, can I invite you into just a slightly different analysis? And you speak about the court used a hybrid approach, i.e., continued with as if it was with the FDA framework, right? Now, at the point at which when FDA is issued, one of the requirements is, because this is basically an application for summary judgment, one of the requirements is that a date of hearing has to be given. And that is slightly different if you follow the other procedure, the ordinary procedure. Agreed? Mr. Kissoon? Right.
It's very
so
different.
When it was issued, a date of hearing was given.
That's correct.
On that date of hearing, the matter came up. As you said, that date of hearing was the 16th of November, 2020. And the papers had not as yet been served. Is that agreed?
Yeah, yes, Your Honor.
Right. So under the rules, if a FDA is issued and not served, what are the options of a judge at that point?
Well, Your Honor, at that point, prior to the hearing of the application,
No, I'm not prior to. I am on. A FDA is issued. You get a date of hearing. You have a situation where that has happened on the 16th of November 2020 at the date of hearing. The papers have not been served because that's the factual matrix in this case.
Yes, Your Honor.
Right.
The matter ought to stand dismissed.
So that non-service, it ought to stand dismissed.
Yes, be it out of the jurisdiction.
What is the rule that says that?
Well, Your Honor, I will look for that shortly.
All right. So while you look for that, here's my question. Why cannot, it not having been served, a judge order service? Because you can at that stage, it's an application for summary judgment. You discover there's an issue with service, give directions for service and a new date for the hearing. That is to say, no hearing has in fact happened. What has happened is there's been non-service, and therefore a court sees of the matter, gives directions for service, which I believe happened, and gave other directions.
Well, Your Honor, the court's approach there is eminently reasonable. Except
No, is that permissible? But I'm on a question of law. Is that permissible under the rules? Because the rules say that, if it's not a nullity, it's an irregularity. And the only reason why the hearing can't go on at this date is because there is no service. The whole idea of summary proceedings is you serve the other side, you put all the evidence, that's what 8042A says. You put all the evidence and you give the other child an opportunity to come and answer. And depending on what happens at that hearing, you may or may not enter summary judgment, or you may do the 8.45 approach, right? So what I'm trying to get from you as a question of law in this case, on the first hearing, it not having been served, was it procedurally open for the judge to say, let's take away the supplemental affidavit piece, serve it in this way, and return to me on a future date? Was that procedurally possible and lawful under the CPR?
Yes, Your Honor, we would believe that to be permissible.
All right. So the judge did that in this case, plus something more. Agreed?
Yes, Your Honor.
And that something more was, the judge said, file a supplemental affidavit. And ordered that be included on what is served on the, in this case, you call it a respondent because you have applicant respondent. Agreed?
Yes.
All right. What is unfair or unjust or procedurally inapt or irregular in doing that on a FDA? Because we've not as yet had a hearing. The matter has come up before court, but you've not had a hearing because it's not been served.
Well, at that point in time, we don't think that anything was impermissible at that point in time.
So therefore, you accept that the judge could permissibly, under the CPR, have given a new date for the hearing because there was non-service. Two, given directions for, in this case, supplementary service, or is it supplementary or supplemental? I'm not too sure. Substituted, I'm not too sure, but given directions for that. And you agree, could have ordered filing of an affidavit or further evidence, so that all the evidence would have been before the court from the applicant's point of view on the new date. You accept that?
Yes, Your Honor, we do.
All right. Good. Thank you.
However, despite either analysis, on the date for hearing.
Which date?
Which date, Mr. Kissoon? Thank you, Judge.
The date that was subsequently set by the trial
And what
judge.
date was that?
Yeah.
You want to put up the flash sheet there, please?
It have been the 18th of April.
Yes, turn out to be the 19th.
Yeah.
Are you speaking of that date, Mr. Kissoon, or date before that?
No, the date I can only infer that the date of the hearing was the date of which the decision was made after the trial judge reviewed the papers that were before, which I believe to be the 18th of April. 18th of April. Yes.
2021.
And that was the date of actual hearing.
Yeah. Yes. Yes, John.
Mr. Kissoon, if we go back to the fly sheet, I think the date of the actual hearing is the 19th because it would have been revealed that the 18th was a Sunday.
Mm-hmm.
So just to if we could just confirm that, I think based on the fly sheet, the date of the hearing was the 19th of April.
That's correct. April 19th, 2021 at 1:15 p.m.
And
So
the
Kissoon,
judgment was entered on the 20th.
So, Mr. Kissoon, my question theoretically is this. On the 19th of April, 2020 at 1:30 p.m., I'm not negating your other arguments, could the judge on the 19th of April 2020 at 1:30 p.m. on the evidence that was before the judge, i.e., the evidence contained as first file and as supplemented, could a judge on that date, on that evidence, have entered a summary judgment if it was possible, etc., etc. Suppose everything else was regular.
Yes, Your Honor.
Agreed. Okay, good. Thank you very much. Yeah.
However, it's our on our review of the evidence that was before the trial judge, we respectfully submit that what was proffered was not sufficient to substantiate the claim that was made. And
Sorry, where are we now? Are we at the first hearing, November 16th, 2020, or are we now at the 19th of April, 2021?
we are on the 19th of April, 2021.
Oh, I see. So is it then that you are reneging from the original position you had, which was that which was that the hearing of the fixed date application was in fact on November 16th? You're agreeing with my brother that the hearing, I'm asking, was in
Yes.
fact on the 19th of April, 2021?
Yes, Justice.
I see. Okay.
But be it on whatever date, in either circumstance, with or without the supplemental evidence, it's our respectful submission that the trial judge was plainly wrong in making the finding of fact that monies were owed to the respondent. And the basis for that is to be found from pages 1232 of the record, where the evidence that was submitted in support of the alleged debt did not reflect any substantiation of monies owed from the appellant to the respondent. For example, a credit card was proffered as proof, which was issued by a company, HDM Labs Inc. A wage statement was issued showing wages paid to the respondent by HDM Labs Inc. Correspondences between unrelated companies to this transaction, A&G Group LLC and HDM Labs Inc. were proffered. A sales order for food and beverage issued by a New York company, Spice Catering Inc., on several of those, and an invoice to HDM Labs was also proffered.
Mr. Kisun, perhaps to help you save your time, I think it is very clear from your submissions before us and the submissions in the court below that you're saying the documentation does not support the existence of this debt, correct?
Yes, Your Honor.
Right. But was it not open to the judge to accept the evidence of the claimant that there was this debt?
Well, Your Honor, if the court means that because there was no one else to proffer an analysis as to the debt, and the court ought not to have looked closely as to what was proffered, we do believe...
With respect, Mr. Kisun, you're not getting my point. It can be that a claimant comes to court and says, listen, I don't have any of the documentation. The only thing I have is this document signed by the defendant. And I'm giving my testimony that we had a course of dealings between us, and that document reflects our agreement that what is owed to me is $300,000 US. Could a court not accept that evidence without documentation?
Well, Your Honor, we believe that if that documentation revealed that there was a debt owed of $300,000, then the court could have accepted it.
No, Mr. Kisoon, you cannot do that to me. I'm telling you, absent documentation and simple evidence, direct evidence that it was owed. No documents. They were burned up in a fire. They never existed, whatever. A court confronted with a claimant says, this person owes me $300,000 and I state this as under oath and I'm asking the court to believe me. Can the court not choose to believe the person? Yes or no?
Yes, the court can choose to believe the person. The difficulty here is that the court will be looking strictly at documentary evidence and assessing the weight and credibility based on the affidavit. This affidavit, it says the one line, I am owed $300,000.
So, Mr. Kisoon, is it all right? So just to build on what my brother is asking, on the 19th of April 2021, the court had the applicant's evidence as supplemented, plus what from your client, if anything?
Nothing.
Nothing. Okay. So the court only had the applicant's evidence as supplemented. Yes?
Yes.
Because on that date, that was a judgment entered in the absence of your client.
That a hearing that was held in the subsequent judgment.
Correct. Yeah. But the court was satisfied about service.
Yes.
Right. No, I know you are disputing it. So the scenario is this: a court satisfied about service has only evidence from one side that is therefore in law undisputed. The court assumes that there has been service and the other side has made a choice not to attend or contest. That's the assumption the court is operating under for now. At that hearing, the court has the undisputed evidence of an applicant. Hence, our brother's question. If a court satisfied of service has the unchallenged evidence, simply, as our brother has summarized it for you, is a court in that circumstance entitled to enter as a matter of law a summary judgment for the sum claim and affirmed by affidavit, etc.?
It's our respectful submission that if the court looks at the documents that were submitted and it doesn't evidence the claim made, then the court would not be entitled to enter judgment in the manner requested.
So you have to satisfy us as to the legitimacy of the entry of judgment, that the evidence before the trial judge on that date could not have supported the entry of a summary judgment for $300,000 US. That's your case, right?
Yes, sir.
All right. Good.
Mr. Kisoon, could I ask you a question which perhaps should logically have come earlier? Are you conceding that the fixed date application being based, it seems, primarily on the promissory note, could be converted into a cause of action based on a simple contract? I think that in the courts below, your colleague opposite had no difficulty with saying that that was certainly the case. That is not disputed on your part. You accept that?
Your Honor, we think that the statement of claim would have had to have been amended to change the causes of action that were contained. Well, the fixed date would have had to be amended to flesh that out. On the face of the fixed date, it is simply a claim to enforce a promissory note, which has never been changed.
Yes, but the law cited by counsel opposite suggests that there can be a conversion from the promissory note into a simple contract. And of course, it is that conversion which gets us into the discussion we had just now. I'm just trying to get from you whether you have any difficulty with the idea that the promissory note not meeting the requirements could be seen as evidence or part evidence of this simple contract.
Yes, it could be, except that in this circumstance, the parallel evidence which was submitted far predated the note. In other words, these documents were dated in 2012. So when looked at everything together, in addition to not being between the same parties and so on and so forth, the totality of circumstances could not in any circumstance amount to sufficient proof of a simple debt. In addition, the promissory note itself was variable. It said $300,000 plus rent at $900,000 a month for an apartment. It doesn't specify the time, or what period of time, and so on and so forth. And when the trial judge, having looked at that note, thought, well, look, I need something more to satisfy myself that $300,000 is owed. Please submit to me the evidence in support. That evidence in support, it's our respectful submission, could not under any circumstance amount to any portion of the amount claimed and in the manner claimed by the note. And that is where, Your Honors, we respectfully submit that the trial judge fell into error, because we believe that if the trial judge had considered that evidence that the trial judge requested, it could not have satisfied her that the claim could have been substantiated on the balance of probability.
I'm happy you added those last words. What is the standard of proof? Just to clarify, you are, for your point of view, the standard of proof is on a balance at this summary stage.
Yeah, it will be the balance that is the standard that is usual and customary in all civil.
Right. No, I'm just clarifying for the record so that you are, the standard is on a balance. There's no higher standard on a summary claim, right? It's just on a balance.
Yes, sure. Yes, sure.
Yeah. Okay, good. Yeah.
And separately and apart from the evidential difficulties that we have submitted to the court, that we believe that the trial judge ought to have considered, and if had been properly done, would have resulted in the claim being denied. As it relates to service out of the jurisdiction, and again, this is a minor point, but the affidavit of service that was on the file did not reveal that the supplemental affidavit, which the court had ordered to be filed, was served. And for that reason, we do believe that on the hearing date, the judge ought not to have been satisfied that service was complete and effective. Separately, the respondent raises an argument with which we don't disagree, that at some point an application to set aside the service for the, we have various quarrels with the service of document, another being that the ordering service out of the jurisdiction ought to have specified the time in which it had been served. These are minor legal points.
Sorry, Mr. Kisun, could you make a note of the point you are going to deal with now, because I want to take you back just one step to something which you said earlier.
Certainly.
You were talking about the non-existence of evidence, or perhaps a weight of evidence. But I'm wondering, a judge who is satisfied that papers have been served and who has the claim before her, is the judge not required to consider, as regards the sufficiency of the evidence, well, look, the other side have not come before me to dispute this debt. They have not come before me to challenge this evidence. They are not denying that $300,000 are owed. Therefore, I have no choice, given what is before me, even though in a contested hearing it might not have been sufficient. Given that this is a non-contested hearing, I have no choice but to go ahead and uphold the claim. Help me there, please.
Your Honor, we believe that under any review, the judge ought to be satisfied that the burden of proof has been discharged. And it is our respectful submission that in this circumstance, a simple review of the documentary evidence would have revealed that the then applicants.
Mr. Kisoon, let us not quarrel about documentary evidence. I have it very clearly that you are insisting that the documentary evidence needed to support the existence of this debt, and that absent such documentary evidence in support, the judge could not, ought not to have found that there was the debt, right? So I have very clearly that position. I ask you to indulge me and deal with it on the basis that if such documentary evidence was not as a matter of law necessary, could the judge, in considering the evidence, the position on oath of the claimant that this sum is owed, could the judge not have taken the view, well, listen, the defendant has not come to dispute this claim, and therefore my hands are tied. There is only one thing before me, a claim supported by evidence on oath of the existence of this debt. Therefore, I am bound, as a matter of what is before me, to accede to the claim. Help me with that. Leave out documentary evidence. I beg you.
Mr. Kisoon, just to nuance something there and respond to both. And that's the procedural law on admissions. So as you respond to what our brother is asking, just also filter it through the CPR principle of admissions on pleadings, because I think that may be also part of what our brother is raising with you. Given this, and a non-contestation or appearance, does that amount to an implied or actual admission as a matter of procedural law?
Well, Your Honor, we respectfully submit that the trial judge, given the fact that it had to review evidence in this summary procedure, needed to be satisfied that the burden of proof was discharged. And as it relates to admissions, again, because this is not a pleading, but rather a hearing on an evidence, the judge had to review and come to a finding of fact. So for those reasons, we believe that the trial judge couldn't or ought not to have simply said that, look, there's no one here, and accordingly, I must stand to conduct a limited review of the submissions made or believe the oath that was put in front of me. The trial judge still, because it's a summary proceeding that is being dealt with as a trial, ought to have made an independent assessment outside of the factors which the courts have raised. The fact that no one appeared, the fact that it was served, and so on and so forth.
I think we get that submission, Mr. Kisoon. Thank you.
Certainly, Your Honor. So in this particular circumstance, the respondent raises a point that service could have been set aside by the provisions of CPR 7.09. This point wasn't raised before. We didn't articulate it before, but certainly having cited the argument, we do see that there is an opportunity for an aggrieved party to make that application. However, because a final judgment was entered after a hearing, we are not sure if, in fact, the trial court at that point in time became functus pursuant to the principles set forth in Narine and Natram and Gilbert versus the Queen. In other words, the judgment having been entered, we were now a victim to what is the appellate process, not having an opportunity to put any evidence before the court as to what our defenses could be.
May I interject?
Mr. Kissoon, are you saying that if a default judgment is entered, you can't move the court to set it aside under the CPR?
Your Honor, we respectfully take the view that this is in no way, shape, or form a default judgment.
Okay, so you distinguish that. Okay, good. Mhm.
And Mr. Kissoon, to take the matter one step further, if a judgment is obtained improperly, so that there is the contention, the possibility that it is a nullity, can you not move the court which issued that judgment to set aside its own judgment?
Yes, Your Honor. But in this particular case, the judge would have been satisfied the service was properly effected, pursuant to rules and procedures that she put in front of her. In other words, she had conducted her own hearing.
Right. But you are contending afterwards, and unfortunately, you did not do it before. Well, you did not apply it before the judge, but you did not do it before the full court either. You are later contending that there was not, in fact, receipt of the document.
No, Your Honor. That argument was proffered at the full court. Clearly, I mean, that was the basis of the proceedings that were filed. But in response to the specific issue of whether or not an application for service to set aside service could have been made in light of the judge's observation that, look, what happens in this situation of a nullity, we respectfully submit in any event that argument doesn't affect the merits of our appeal before the court, because as the courts below treated this matter, it was looking solely at the four corners of what happened at the hearing. And we, for the reasons we previously articulated, we don't believe that the trial judge was correct in any event at coming at her decision.
Mr. Kissoon, let me tell you what has deeply engaged me with this case. Can you, without setting aside a judgment, really be heard, apart from objections in law, etc., as to the nature of the judgment? Can you be heard to argue against the merits of the process by which that judgment was entered? You have not applied to set aside, so you have a judgment which was properly entered against you. How can you be heard to argue against said judgment? Help me.
Well, Your Honor, if the court were to find that one could not properly argue against the process of the judgment, we still respectfully submit that the court could of course look at to see if the merits of the underlying matter and the principles applied outside of process and procedure were properly applied. And in this particular instance, we say that it was not. No.
But counsel, now this is where your functus point seems to come in. If there's no application to set aside, your point is that the judgment is res judicata, the court is functus. So how can you ask a superior court, an appellate court, to inquire into the process by which that determined judgment was arrived at? Help me here, please.
No, Your Honor, forgive me. I think I may not be understanding the court's question, and that may be revealed in my answer.
Okay.
Once the judgment is issued, it still becomes an appealable paper on certain aspects of what have been decided by the court.
Right.
So, for example, if the court is saying that because you didn't avail yourself of the remedy to challenge service using the proper process and procedure, or that the court's process of service was improper, well, that's not something that we can look at now. That's certainly different from looking at whether or not the judgment should have been issued on the merits of the matter.
Do you cite any case?
You're saying, Mr. Kissoon, if I understand you, that your complaint is that on appeal, you're restricted to looking at errors of law that may have been committed by the court below. and you're not able to appeal on the merits of the case. That is the essential gripe, essential complaint.
Yes, Ron.
You have been boxed out of presenting a defense to the claim.
And we could look at this as to what ought to have been done in a myriad of possibilities. But the reality is here that the appellant is strenuously trying to put before the court that he has an absolute defense of many defenses to this claim, and for one reason or another, because he did not appear in court, he has now been forever shut out from making that submission. That is all that the appellant is appellant just wants an opportunity to say something in court substantively, which has forced us in a straitjacket to deal with this matter in this manner.
Sorry.
Point, but because you did not, oppose service or make an application to set it aside, the court naturally is of the view that you were served and you did not appear. So it went on to make the decision it did. I'm not quite sure how we unscramble that.
Well, Your Honor,
Mr. Kisoon, before we respond, can I just add to what the chair has raised, Part 709? Because doesn't Part 709 give you exactly what you have just said you want? I.e., that if you are challenging service, you come to the court that made the order, you satisfy the requirements under 1A, and you can also establish what is set out at 709(1)(c), i.e., basically merits. In other words, you know what? Look, they can't succeed on their claim. And therefore, the door is open for you to do exactly what you want. You made a choice not to do that. You are suggesting to us, and I must confess, I am still not yet persuaded, that you couldn't do that. So if you couldn't do that, then I don't understand. The purpose of 709 is exactly to do what you have just raised, i.e., and it stands to reason, service is integral to due process. And a consequence of non-service includes several things, summary judgments, as in this case, etc. What do? 709 tells you, hold on, if you have not been served, that misrendering of due process is so sufficient that you could come and get all the benefits you want to get under 709, which includes showing that that there is no good reason why the judgment should have, etc., etc., etc. I don't understand how that becomes functus, because what that is saying to the primary court is revisit what you did, because what you did was based on an assumption of service, which is an erroneous assumption. And therefore, 709 gives you the entry point before that forum.
Certainly, Your Honor.
You agree with that?
Yes, we accept what the court is saying. We note a few things in that regard. This observation is being raised at the first time here, and perhaps if it has been raised at the full court, the parties could have then used that process. Two, in any event, in the manner that the case was presented, perhaps either the full court or the Court of Appeal ought to have on its own, in assessing the merits of the matter, made such a direction pursuant to that provision. And
sorry, hold on. Which direction?
That the service be set aside.
That's not a direction. Hold on. That's not a direction. That's an order.
Well, Your Honor, ought to have.
Why would the Court of Appeal have done that? The Court of Appeal observed that there has been no application to set aside.
Yeah, I'm afraid the responsibility is on you, Mr.
No, fair enough, Your Honor. So assuming that all of that has gone by the wayside, In any event, we respectfully submit that we are still allowed to look at the analysis that which we undertook earlier, not relating to service, but the merits of the matter as we have proffered them to the court. And in that circumstance, because it was a fixed date application and a hearing was held on its merits as a matter of what was before the trial judge, we respectfully submit that the court can still consider whether or not the trial judge was correct. Because
and that is the basis of your appeal. So your appeal now reduces itself to a simple question or a singular question of law and fact. Because this is an appeal, you accept, it seems, that the other procedural stuff needs to fall by the wayside. We've explored that. Your question before us is this. On an appeal, we want to review the merits of the entry of a summary judgment in the circumstances of this case. And your argument is, one, there is an obligation on the first tier court to do sufficient due diligence to meet the standard of proof because it is a summary hearing of a matter. Two, if that due diligence had been done by the first tier court, the standard of proof, which is the balance of probabilities, could not have been met on what was before the court. And therefore, as an error of the first court and the Court of Appeal fell into an error of law on the facts in the circumstances in entering summary judgment. Is that an accurate and fair summary of what your submission is, Mr. Kisoon?
Yes, Your Honor. That is what we're left with.
Is there anything else in this appeal that you can argue, given what our conversations have been?
No, Your Honor, except that we wanted to raise two ancillary points that arose out of the process of this appeal, which we would respectfully ask the court to consider whether it could give guidance on. I would like to proceed to those two questions briefly, unless there are any other questions as it relates to the substance of the appeal.
Before,
go ahead. No, my brother, go ahead. It's fine.
Before you so proceed, Mr. Kisoon, did you raise this before the Court of Appeal? The ancillary questions. You see, the problem is this. Ultimate appeal courts do not like to pronounce upon matters which the courts below ought to have pronounced upon, which they should have been given the opportunity of pronouncing upon, which they, with their greater knowledge of the minutiae of practice and procedure in the courts, would be able to shed greater light upon. So did you raise this before the Court of Appeal?
In discussions with the judges, yes. It's not a matter of a record where it forms an appealable paper. If we had to distill what we are asking the court to guide us on, forgive me, I know the court is trying to stop me from getting into it, but I just would like to ask the court the question, if the court would give me that little latitude, as to whether or not, whilst an application for leave is pending for appeal in the Court of Appeal, when an application for leave is pending, can the court, prior to the grant of leave to appeal, issue a stay? And this is a matter that has plagued and is plaguing practitioners. It plagued us in this case, where the court refused.
Mr. Kisoon, Erinford Properties, I forget, Justice Rajanath, you remember the date. Erinford Properties. I mean, is it that your courts are saying they cannot?
Yes, Your Honor.
Oh, I see. Okay.
Absolutely. And in this particular case,
sorry, and you cite that decision to us?
No, he doesn't cite Erinford. I'm asking him if he's aware of
any decision.
Oh, yeah, sorry.
Your Honor, during the break, I will pull it up. I believe we've put the summons.
But, Mr. Kisoon, how could you do this to us? You are asking for our determination on a matter. You are now saying to my brother that this is a view held by the courts in Guyana, and you have not put before us any decision in which that view has been held. you will appreciate that we do read your skeleton arguments, we do read your written submissions, etc. So we are aware of the existence of these ancillary matters that you have raised. We have seen the response of the other side, which says, really, this is a waste of time because it is quite clear that the courts can, in fact, make this order for a stay even before an appeal or leave to appeal has been granted once there is an application, etc. So I am loath to be engaged with it when I don't know what value our pronouncing upon something which is not properly argued before us, which is not in fact even an issue in this appeal, is the situation.
We are aware of your concern, Mr. Kisun, and we will certainly bear it in mind. But for the reasons given, I don't think you should expect any detailed guidance from us on that point. Those 2 points. Is there anything else that you wish to urge on us?
Not at this time, Your Honor, except as I said earlier, the applicant does have a complete defense to this matter and is respectfully seeking a mechanism, if not to have the underlying matter dismissed, to have his case heard. And we would so ask that the court grant that.
Yes, we noticed that those were some of the reliefs that you asked for, and of course we will consider those. There's a very small point to make, Mr. Kisun, and that is that at the apex level, we tend to have fewer grounds of appeal than are mentioned in the Court of Appeal. I noticed that on this occasion, you seem to have had fewer grounds in the Court of Appeal than you put before us at the CCJ. We're not accustomed to that, so that might be something you might wish to bear in mind. And of course, the discussion this morning, I think, could be summarized in maybe 3 points that were covered in your submissions and questions to you. So just something to bear in mind.
I'm guided, Your Honor. Thank you.
Thank you very much.
Be well.
Okay, Mr. Datadin, please, sir.
Good morning, Your Honors. Your Honors hearing me clearly?
Yes, we are, very clearly. But it's clearer when you lean forward.
I will do that, Your Honor. Let me make some room. Your Honor, the appeal before you relates to a debt. There has been no application in any of the courts below along, Your Honor, Justice Barrow has disappeared. I'm not sure if he's.
Yes.
Oh, sorry, Your Honor.
He's very much here. Yes.
Sorry, Your Honor. So, Your Honor, none of the what we have now had in this court had been raised in the full court. A substantial amount of it had not been raised in the full court, nor the Court of Appeal. In the Court of Appeal, the main subject and thrust of the merit was one that it was made under duress. And I think the Court of Appeal addressed the merits as well, to say even if the court had been aware or this defense of duress was being raised, that it could not be raised because the time that had elapsed since the duress would have come to an end. On the basis of what was before the court, Your Honor, I think respectfully the High Court, when it was seized of the matter, was entitled to come to the judgment that it did. I think the court has traversed the several aspects that had been raised that engaged the full court and the court below principally. But Your Honor, it continues to be an evolving response from the appellant. It's almost like trying to solve a Rubik's Cube that's fighting back. Because at every stage and at every level, we keep having an evolution of what the appellant is trying to say. Your Honors, under any circumstance, if there was, and Your Honor, I understand that it has raised some concern, or the appellant is raising some concern about whether 709, that if there is service and the court has ruled whether you can make that application to the court using 709 to set aside that. And Your Honor, respectfully, that has happened, where matters have been filed, judgment has been granted, and the party alleges that there was no service. They have engaged, following a judgment being made, they have engaged 709 to go to the court to say what you have as service, or what your record of service is not so, and we in fact did not receive it. And the court that made the judgment has engaged and listened upon what was said. And respectfully, Your Honor, we don't think that that in itself is a bar, that the fact that judgment would have happened, that the court would have been fountas. We respectfully don't see that as being a bar to what has happened.
Mr. Datadin, are you comforted by the knowledge that the Court of Appeal has said that you have failed to apply to set aside? Do you
Yes,
find that there is greater force in your argument for the fact that high judicial authority has already stated it?
Yes, Your Honor.
Then perhaps you should simply rely on them. Go ahead.
I am guided, Your Honor. But Your Honor, again, what the appellant is saying to the court is that they would like an opportunity, or in some shape or form, they would like an opportunity to be heard and to advance whatever is their case. But Your Honor, that opportunity was always available to the appellant to exercise in any form that they wished, instead of going through three courts, which is the full court and the Court of Appeal, and then this court, with a position that seems to be saying we have not had an opportunity to have the merits considered. There was no effort made before the full court to introduce any evidence. The rules provide for it. You can ask the court to consider additional evidence that was not considered in the court below. You can explain why it wasn't considered in the court below. Indeed, in the Court of Appeal, if there were and if there was going to be additional evidence, it would have had to have been done in the court below. And what is being advanced
So, Mr. Datadin, on the record, the evidence of duress comes from where?
Well, Your Honor, principally, the submissions, it is not, what is exhibited and is part of the record, Your Honor, is, just 1 second, Your Honor. In the Court of Appeal, it was raised and considered by the court, Your Honor. Give me my file. Yeah. And the Court of Appeal, in its decision,
What I'm trying to ask you is, Mr. Datadin, is what is the source? What is the source? What is the source?
Oh, what was alleged, Your Honor, is
no,
that...
Yeah, no, not, I know what was alleged. I know the argument. What was the basis for bringing this argument forward? Was there an affidavit sworn by the appellant?
No, Your Honor.
So how does the evidence of an allegation of duress, of a defense with a prospect of success, how is that fall to be considered by a court of law?
Well, Your Honor, you have gone ahead a little of what I was going to say, Your Honor, in that the plethora of things that are being raised are not being put before any court except principally in legal submissions, and matters that are being raised in where submissions and explanations are being offered. But Your Honor, if there was and if there is evidence to be considered, then a court would be requiring it, presumably in the format that we are, by way of affidavits that would need to be sworn.
So is your submission, sorry.
No, go ahead, Judge, because I wanted to raise a different point.
No, so I just want to clarify that is it your position on the record that the appellant has never put before any court any evidence upon which it can raise any defense on the merits?
Your Honor, there was no affidavits sworn in the full court. It was a comment that was made by the full court in its judgment to say that issues have been raised in submissions, legal submissions before the court, and that is not the proper place for it. And the court, there was no application that was made to the court to offer evidential material of any kind.
Okay, thank you.
And you say the same for the Court of Appeal, Mr. Datterton?
Yes, Your Honor, from what I was not counsel in the Court of Appeal, but from what the record has, there is also no evidence that is sworn to or being introduced to the Court of Appeal in the matter as a part of the appeal for consideration in that appeal. It again forms part of what is before the court in the submissions being made to the court, but it doesn't form part of any of the evidence that is being sought to be considered by the Court of Appeal.
Yes, Mr. Datterton, I think we follow you on that. What I wanted to ask you was something slightly different. What is your understanding and your submission with respect to whether this appellant could have approached the Chief Justice to set aside that judgment?
Your Honor, if I may deal with it in two ways, in that I know that it is being approached in the courts from my humble experience, Your Honors. The first is in issues of service or anything related to that. Rule 7, CPR Part 7 is employed. In other matters, there is a reliance on the inherent jurisdiction of the court if there is an irregularity to raise it with the court. There have also been applications, Your Honor, that are made by the co-joined effect of the CPR rule is 202, Your Honor. Just one second, I'll give you the. Just one. Your Honor, under the CPR, there is a provision under 2023, part 2023, 2.023, that permits if if there is no specific rule to provide for a procedure in these rules, or it is silent as it relates to that, that the old High Court rules which existed before it could be relied upon. And applications have been made with that, and there is a specific rule in Order 25, Rule 13 of the old High Court rules, which is that ex parte or judgment in default, the court may set aside it upon an application before it. So they have been, they are, and they have been that procedures where this has arisen, where they have persons have either relied on the inherent jurisdiction of the court, persons have relied when it relates to service on 709 of the CPR, and in other instances they have relied on a specific ability of a rehearing of the application by relying on the co-joined effect of the two rules that had existed. Now, in all of those scenarios, Your Honor, there is always the merit threshold that has to be met, and you have to show that you have a defense, and you would advance all the defense to say what it is that has happened and what injustice that has occurred. But Your Honor, there must be, and respectfully, Your Honor, I understand the appellant's position, Your Honor, that they're saying that they have not had an opportunity to be heard, and the High Court judge ought to have considered other things and been more cautious. But Your Honor, the opportunity is at every level to swear an affidavit, and even if you wanted to borrow from the Ladden-Marshall principles and you have committed to filing an appeal, to ask for additional things to be considered by the court. The rules of court and the procedures of the court have always engaged that. The path of choosing to appeal, Your Honor, is a path whereby only the consideration of what has been before the courts below can be considered. And this has happened, this is what was said expressly in the full court, that we could only consider that which was before, that there has been no evidence or no effort to put any evidence before the court except in the submissions, which the court said they were going to disregard because it wasn't the proper place to introduce such material. The Court of Appeal likewise engaged in a process which said that was the position as well. Your Honor, even in this court, there is no affidavit evidence or introducing any evidence to say that this court should consider any form of evidence. The appellant keeps saying repeatedly in the courts that the court is not considering his evidence, but he's making no effort to put that evidence to the court. He's making no evidence to put the evidence before the court in a manner that an adjudication can take place. Repeatedly relying on what the trial judge would have done, respectfully, Your Honor, is the trial judge conducted the trial in a manner in accordance with a fair trial, made decisions that were appropriate so that the matter could have been resolved. It's been nearly...
As we're at this point, Mr. Dattadin, would you accept the appellant's analysis as to what happened in relation to the FDA, that the FDA was really heard on the 19th of April? Is that also your position?
Yes, please, Your Honor.
Okay.
Your Honor, the position was, and I understand the arguments that have been raised about supplemental affidavits being filed at a hearing, but it wouldn't have arisen for a hearing at that time because the service would have had to have taken place. And Your Honor, the courts in Guyana have on more than one occasion of considering a fixed date application allowed a litigant who has come before it to remedy what they see as something that ought to be remedied. Your Honor, I respectfully submit that a court has that power. That's an inherent power in a court, as opposed to dismissal. Recently, just 2 weeks ago, in the Court of Appeal, in the High Court, where an FDA was filed against the wrong party. It involved the Environmental Protection Agency, and the action was intituled against the director personally. So there could have been no remedy brought because it could not have been, the director personally had no power. Your Honor, the court accepted that instead of going to refile the entire process, that it would allow that an application, that an amendment be made so that the proceedings could proceed. Your Honor, the court respectfully, while the civil procedure rules would dictate and direct a particular path, I don't think that it takes away an inherent power of a court to say, well, we can deal with it. But I don't wish to raise what other matters in other courts. But Your Honor, it's not. I just say that to say that the courts in dealing with fixed date applications have not been at the first hearing, if there have been matters that needed to be rectified, simply striking it out. They have been allowing amendments, and they have been allowing supplemental affidavits to be put in, and they consider it to be a part of case. They're handling cases in a manner that doesn't waste judicial time.
Yes, that's a very interesting point, of course. And the question could have been raised about whether that is, strictly speaking, in line with the CPR rules. But that point does not arise in this case, obviously, because the other side has conceded.
But Your Honor, respectfully,
yes.
I think that in the thrust of what the appellant is raising and continues to raise about the opportunity for defenses, the opportunities of duress, the opportunities of the simple contract and the evidence that was before the court, Your Honor. It's been several years that the process has been going on. It's been several years since all of these things have been engaged in the court. The respondent, respectfully, Your Honor, must be entitled to have a resolution of the proceedings. And it is a fair resolution if the appellant will not engage or perhaps entertain that at some stage, if the complaint is he's not being allowed to put evidence before the court, to attempt to put evidence for consideration before any court. Because what is the appellant therefore saying? That we have embarked upon a course, we have chosen a path.
Mr. Dattadine, I think you made the point.
Yes.
There's no evidence. Yeah. So can you address what I think Mr. Kissoon ultimately rests on primarily, that within the context of an appeal and as a question of mixed law and fact, that the trial court that heard the fixed date application erred because, one, there is an obligation in law for the judge. This cannot be treated as an admissions case, an obligation on the court as a judge to determine as a matter of evidence on the standard of proof, which is a balance of probabilities, that there was this debt owed prior to entering summary judgment. And his critique is that, which is the basis of an appeal, as we have discussed, is that that is an error of law and fact. That is to say, there was simply insufficient evidence to cross the threshold of a balance of probabilities. Therefore, the judgment entered should be set aside.
Well, Your Honor, what was before the court? Before the court was a document that was executed by the respondent. The document evidenced confirmation of the payment of monies to the respondent. The court, in any consideration, would be entitled to rely on that evidence on a balance of probabilities, whether considered to be a promissory note or not, to be evidence of a payment of a debt that was enforceable. The document provided support in some aspects to say these are some of the evidence that supports it. But
you mean the affidavit? You mean the supplemental
affidavit, Your Honor. The affidavit outlined in substantial detail the nature of the arrangements. It outlined the nature of what was available to support, in part, what it was.
Mr. Datadin, on that note, as you are addressing us, Justice of Appeal Singh made the point in his dissent that the documents attached to the supplementary affidavit contain evidence of less than 10% of the sum claimed, and he therefore thought that judgment ought not to have been granted on that evidence. What do you say of that?
Your Honor, what it was is it was not the document itself and the affidavit that support were not going to find, or ought not to have been, that it would find the exact amount totaling what it was. The evidence that was provided demonstrated that there was a relationship that existed between the parties. The signed document itself is the evidence. The document on the face of it and is written in the same handwriting, and it evidences what, and it speaks for itself as to what it says. If that party, Your Honor, as it relates to that document, as the appellant has raised in his submissions and pointed out that, and we had put before the court, there was a demand letter sent in relation to that document from a lawyer, to which there had been no response. So a demand had already been made before the proceedings began. There was no response to that, and the appellant has never denied at any stage that he received a notice, and if he thought that the document itself was obtained or did not represent what he said, he could have taken steps to set aside that document that was being relied upon on his own. He could have taken those steps to do that. Your Honor, the letter is dated a considerable time before the proceedings were brought. And that letter, it would be tagged. And that letter was not responded to.
Sorry, what letter is that? The one from the lawyer? The remand letter?
Yes, please. A letter from Nandlal and Associates that was written for the demand. The letter is dated 2019-06-05.
What is the date of the letter, sorry?
2019-06-05.
I see.
Okay.
And Your Honor, that letter is also exhibited and was exhibited in the High Court about the demand that was made. And that letter was also brought to the attention of the court, that a letter of demand had been sent on the basis of this to the respondent. And that is that was the fly sheet. That was noted, Your Honor.
I think that constitutes an answer to my sister's question, unless you wanted to press further. So is there any other points you wish to press on us, Mr. Datterton?
No, Your Honor, not unless the court requires me.
Mr. Datterton, one
Yes,
other matter that I thought that we should put in the mix is that at a hearing before the panel on the 17th of December 2024, we did stay certain execution proceedings. So I take it that if we are with you on it, you would want us to discharge that part
yes,
of the
please.
order? Yes.
Yes, please, Your Honor. I know, and I don't wish to open the door in relation to what has been raised as the ancillary issues by my friend, but Your Honor,
Please do.
We are guided
Please
by
follow
the fact
please
that
follow as to not to raise it. Yeah. So anything further, sir?
no, sir.
Yeah. I don't see my colleagues wanting to ask you any further questions. No. Mr. Kisoon, a response?
Just briefly, Your Honor, we don't agree that CPR 2.02 has an analogy or any room to bring the old rules back into the new. This was addressed by this court in the Medical Council versus Ocampo matter. There is affidavit evidence in this court and in the courts below as it relates to the applications for leaves to appeal. That's the only affidavit.
As it relates to what? I'm sorry, sir, I didn't hear you.
Applications for leave to appeal.
Oh, leave to appeal, yeah. Okay.
So they're both in this court and in the Court of Appeal. Sadly, that's the only affidavit evidence that's before the court, but there is affidavit evidence where the appellant testifies. And certainly all of the applicant's contentions in one way, shape, or form have been maintained throughout the appellate process. There's nothing further for us to address the court on, except to say that we still are of the firm view that there's not sufficient evidence in support of the alleged.
Yeah, thank you, counsel. Much appreciated. Okay, well, I think that brings us then to the end of the hearing of the appeal for this morning. I want to thank you both for your assistance to the court. We will, of course, consider the submissions that you've made and alert you to when we have come to a decision.
Certainly,
Thank
Your
you
Honor, and Mr. Datterton and myself would like to congratulate both yourself and Justice Chantal Ono Nayu on your recent appointments. We're both very proud of you and look forward to our careers together. Be well.
Your Honor, may I just add briefly that we are indeed very proud that I don't want to be categorized as anything, Your Honor, but I only say homegrown is homegrown. I don't want to enter or to cast aspersions anywhere, Your Honor.
Justice Barrow will have you.
especially since there is coming on somebody who you may not consider homegrown. So yes.
You're not hearing Justice Barrow very well, but
Yes, I think he's warning against the use of the word homegrown. Given the composition of the panel may include persons who might or might not fit that description. So just bear that in mind.
No, Your Honor, I mean the region.
Indeed.
Thank you, counsel.
And my sister and I thank you. And the bench, of course, appreciates your comments. Madam Deputy Registrar, would you bring the proceedings to an end, please?
Yes, please, Judge. Thank you so much, Mr. Justice Anderson. Thank you, Madam Justice Rajnath Lee. Thank you, Mr. Justice Barrow. Thank you, Mr. Justice Jamada. Thank you, Madam Justice Ononewu. Thank you, Counsel, and a thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.
Thank you.
Thank you very much.